All right, thank you. My name is Tatiana and I'll be moderating this panel. It is the legal and constitutional problems with the Take It Down Act. But before we jump into the act, what's problems of trying to solve the unintended consequences, let's just quickly have our panelists introduce themselves. Brief background about yourself.
Hi, my name is TJ Mihill, and for finally the last time this year, I am a local attorney here in Atlanta. I work with Stites and Harbison in a building connected here by a skybridge. It's in the food court, and I do business law and IP law and litigation.
Hi, I'm Heidi Tandy. I'm a board certified intellectual property attorney from Florida, also barred in New York. And I have been dealing with DMCA style takedowns for, well, since the act got signed.
Hi, Matthew Lane. I am a senior policy counsel at Pipe to the Future. We are a nonprofit that deals with issues at the intersection of human rights and technology.
Cool. Well, Matt, you want to start us off and just give us a overview of what are we talking about? What is the Take It Down Act?
Boy, okay, so the Take It Down Act, I'm going to go on a small rant if people will permit me. So as someone that works in tech policy, I like to try to keep up to date on what technology is and what's out there. I experimented a lot with the image generation, both provided by the major companies and open source installed on my computer. Researched a little bit about the communities that were developing around building these sort of open source tools. And I thought that it was really cool. I also thought it was incredibly concerning because there was a large portion of the community that was dedicated purely towards making these models for pornography, which I think is fine, but also making deepfake pornography of living people. Like they were literally creating and sharing models of famous people that made it easier to create these images. And, as someone who was in tech policy, but also as someone who's working in a comparatively small organization, I didn't have a ton of time to devote to this. We got some meetings with some of our allies at bigger organizations. My colleague and I worked on writing some stuff, and we're basically like, this is a problem. It is real, it's coming, it's only going to get worse. We need to solve it, and we should be the ones proposing solutions, because if we're not, the solutions that are being proposed will be like bad. And so we saw the Take It Down Act. We thought about it for a little while. And what our analysis is that while the DMCA is deeply flawed, and we have a lot of problems with it, there is enough of a learning curve that we think that it could be workable as a model for taking down these images quickly. And that this bill was the closest to that. That obviously there's a lot of trade-offs here. But if we learn from the past, we can create a system that will allow victims to have quick and effective taking. We had some disagreement with our allies though on this. And where we settled was, we think from the victim's point of view, really the only remedy that's going to work for them at scale is being able to take it down. And that's where the DMCA is, I don't know if anyone watches on YouTube as I do, but it's like a system by which if a IP holder has a right and you're violating that right, they could submit their claim to the platform, and the platform has the tools available to sort of immediately take it down, adjudicate whether or not this actually violated the copyright or not, and then either put it back up or whatever. It's also used a lot for harassment and other sort of money-making schemes. But yeah, so we wrote something that's basically like, we think this bill looks good, but it needs to be fixed. It like has absolutely nothing in terms of learning from the DMCA. It has no protections. We're assuming they're working on those. Turns out that they weren't. The text we saw was the text basically that passed. And so the Take It Down Act basically says that you can submit a claim for deepfake sexual material. There's a lot of definitions there. The platform has to take it down within 24 hours. And those sort of this new right. The sort of problems with it are, one, there's no carve out for encryption. So it doesn't take into account what kind of platform you're on. So technically, and this is kind of unclear, Signal, which has end-to-end encryption, is covered by the Take It Down Act. they technologically cannot look inside a message that's by design. And that question is not answered in the text. And if a judge decides that wrong, it could kill an encryption. Since it is now law, everyone that works for these companies are going to say it's not a problem because they're protecting their arguments for trial. But it is a significant risk. The other problem is that there are zero protections from DMCA. Even those flawed protections are not in there. And so there are lots of ways of sort of gaming or abusing this sort of takedown system to basically target speech you don't like. And even though the definitions for sexual content are relatively well defined, the 24-hour time period and the potential volume of claims means that there has to be automated systems, which means that savvy people that want to use this as a way of attacking speech can figure it out how to use this to mass target speech. I don't think there's really anything in there about putting it back up or any sort of guidance. And so we'll get to South Park later. But
Matt, you gave us a lot of content there to go off of, but I want to take one step back for a second. And TJ, we were talking about this a little bit before the panel started. Can you talk a little bit about what the landscape looked like before Take It Down? What kind of issue was it trying to solve for, and what does it look like now that Take It Down has been passed?
Sure. So, for those of you who've been around the EFF track as long as I have, you might know that I've been doing talks on revenge porn since before revenge porn statutes existed. Back in those days, we were telling people to shoot only selfies and share only selfies so that we could make DMCA claims and hope you live in a state with a good right of privacy or publicity. And that changed in those intervening years because many states started passing revenge porn statutes. So there was remedies for victims beyond just hope you shot a selfie. But it was still now hope you live in a state with a good revenge porn law. So you had so many different laws in different states that it was a confusing system of what were your remedies? What remedies were available? Were they only criminal? Were they only civil? Were they criminal and civil? Were there any prohibitions on this type of content, that type of content? Some only dealt with images. Some didn't have video. Almost none of them, especially the early revenge porn adopter states where we thought we were doing well. Oh, we're doing this right away. We're going to take action on this. But they took action so quickly, deepfakes didn't exist. And so there's a lot of state revenge porn statutes that don't have any way to address what is not really an image of you, what appears to be an image of you, or an image of you that has been manipulated in some way to turn it into sexual content. So the reality is, I believe, that some level of federal legislation is necessary. Not just to give uniformity, but what happens when the victim lives in Georgia, but the defendant lives in Texas? And then the site is the content is hosted on some site, who knows where. Which one of these state laws applies? So having that federal law gives us some federal certainty of what the rules are. You still have the state laws, and you can still proceed under your own state laws too. You still have rights of privacy and copyright claims and all the things that existed before we had revenge. But at least now we have one thing that we can all know and say, this is available to a victim. And we did have that a little bit because the Violence Against Women Act had some language put in to deal with revenge porn. But again, nothing about deepfakes. And there's so much more of that content being generated and shared now than actual content, that this is something that needs to be addressed. I think there are some good reasons for a law like the Take It Down Act. I'm not sure the Take It Down Act is the one we needed.
Yeah, Heidi, during your intro, you mentioned DMCA. It's been brought up a few times. First, can you tell us what that is?
So the DMCA is the Digital Millennium Copyright Act. And I'm going to just throw us back in time about 28 years ago when there was a mailing list still exists, for copyright attorneys and copyright interested law students. Where back in 93, 94, people were talking about, hey, we need new laws to control copyright on the internet because wow, all this infringement. And I was like, no, we can argue by analogy. We've got this case, we've got this thing. And I think I was a second or a third year at the time. And I was absolutely wrong because the DMCA gave websites and content hosts a way to host content that might very well be infringing without running into the risk of having to suffer the damages that exist under the Copyright Act, which are considerable. You infringe on something that's registered, your penalty can be $250,000 and it can go up from there. So it's good to have a law that exists that basically it's a safe harbor. You see something that you own the copyright in and it's hosted on somebody's website, like a PDF of the last 7 novels that you wrote, and they're hosted on a website for people to download or add into their large language module training documents, both of which are bad, and without your permission. And you can have it taken down. You can have it taken out of that content database. Doesn't mean it removes it from everywhere on the internet, but at least it's something that you can do. And then if the site removes it within a reasonable period of time, they cannot get hit with a copyright infringement lawsuit, even if they keep it internally for, legal and managerial purposes. As long as they're not sharing it publicly, there's no copyright infringement suit that you can bring against them, which is great. However, there are 2 big honking problems with the DMCA. Number one, it only covers images that you yourself take, which means that if you're, flashback here, if you're Ellen DeGeneres and you're supposed to take a photo at the Oscars and it's actually taken by Bradley Cooper, he's the one who owns the copyright in it, and whatever documents you created in advance are just completely irrelevant now, and the company that had you take it, Samsung, I think, is going to have to go back and deal with it after the fact. So there's that. But number 2 is the DMCA allows for certain kinds of lawsuits in the event of requesting a takedown. So let's say, for example, if you are a company that has viral videos of weather and you want to file a lawsuit against YouTube to have certain videos taken down and staying down, because the people who used those little video clips are using them for things that they think and reasonably think are fair use. You can do basically what's called a SAD litigation, where you have Section A defendants, or Schedule A defendants rather, and you list a whole schedule of websites and the entities that own them. And if it's a Canadian company or a Bahamian company, then they are a foreign company, and filing a lawsuit against them and against those videos has that content stay down. And even if the lawsuit is eventually dismissed by the plaintiff, by editing it to remove all but one of the entities or something like that, YouTube will still keep all of that content down.
That's helpful. I guess to follow up to that, Heidi, you laid out, how you can take down copyrighted works. How does that compare to now the process under the Take It Down Act, and whether there are any implications there? Wow, sorry. Last day of driving time, my mouth is not working.
Okay. So you can use both of them in tandem. If you're the one who took the picture, or in the alternative, if you're the one who set up the camera, or if 2 people collectively set up a camera together to film themselves, then anything created by those 2 individuals could arguably be a joint work. And you have grounds at the very least to believe that it's a joint work and utilize the DMCA, which does not require you to have a copyright registration. You can then utilize the DMCA to have that content taken down. But if the other person involved in the filming has done something to that content to make it look otherwise, to make it look like something else, then you also have the ability to look to the Take It Down Act, because what they've created might be, a transformative work, but probably is not fair use.
Thank you. All right. So we've talked a little bit about the act, a little bit about the process. I'm going to open it up. What are the unintended consequences of this act? We've heard a lot about encryption, censorship, free speech. So Matt, why don't you start, and then we'll make our way down.
I already sort of previewed, I think, our big ones. I think another one that is worth mentioning is that this also ties into political speech in kind of a weird way, and that's why I said we get to South Park later. South Park had an episode where they had a marked and clearly, I think it was like a composite deepfake where they used an actor and then just put Trump's head on top. But I think they also purposely did it in a really terrible way because it's kind of like stylistically a very South thing to do. And involved him, stripping down in a desert and becoming more and more. And when this episode aired, every professor I know that has worked on this issue was like gossiping on Blue Sky, like, oh my God, did South Park do the first high profile take it down violation? And the analysis is like, kinda, yeah. I mean, if Trump wanted to use that law against South Park, he could have. And, I think that when it comes to speech issues, there is no clear line. Like everyone thinks that, if it's a like actual pornography of like an attractive lawmaker, especially women, that's highly abusive and wrong, especially if it's not marked as being deepfake. And it could do a lot of damage to them personally and in their career and other things. That seems clearly wrong. And then like this South Park Trump thing is like, oh, that's clearly like political speech. But like there's so much gray area between. And so it's really hard to sort these things out. Take It Down is kind of a blunt hammer for this. And so, I mean, the stuff that feels like it's politically like speech can get taken down just as easily as stuff that feels like wrong, like from a societal level. And so these things are hard to deal with. And Take It Down is just very blunt as a tool. There's no sort of nuance to it.
So one of the other things about the major multinational content host companies is that they're probably more likely to listen to you if you have an issue by somebody reporting something as a deepfake or as a DMCA violation. If you have a good relationship with them, if you're an advertiser there, even if you just have, a validated or a verified account. Because then you make a contact person that you can reach out to. And that comes into play when, especially in connection with media coverage of these various things, because there isn't anything in the Take It Down Act that says coverage of something that is a Take It Down Act situation would, is somehow protected. Like there's no news reporting, there's no educational exemption in the act that would absolutely cover all those kinds of situations. And that is something that a more cautious attorney, GC, or outside counsel for a news organization, especially a smaller one, might not want to go there just because of the risk of private right of action of a lawsuit or of an action by a state attorney general under not so much the Take It Down Act, of course, but under a privacy statute in a specific state. Just bouncing back very quickly, DMCA is entirely federal. States do not have their own copyright laws. And any argument to try and make a state copyright law would absolutely be found to be preemption, if not on a state level, then on a federal level. So there is some concern from, in a theoretical sense, because I don't think any of us know how many times this has practically happened, but that news organizations might be refraining from creating coverage, creating content of these various things because of the risk of a lawsuit. And it might be their GCs, it might be the insurance company that is, giving them insurance, for infringement, for law violations. It's also a potential breach of contract situation. Nobody wants to jeopardize their ad revenue and their business partnerships by being found liable or frankly being accused of, which is something that's in a lot of contracts. If you are, viably accused of a violation of a law like the Take It Down Act, then that could be seen as a breach of certain kinds of agreements. And that's something that's risky for, businesses large and small.
I think that my biggest concern with the Take It Down Act is not what it potentially captures in the umbrella, but how it deals with what it's even legitimately trying to capture. The issue is that, and Matt alluded to this a little bit earlier, the DMCA is materially different than the Take It Down Act in two ways, and they're incredibly significant. The DMCA requires you to take down content in a reasonable time. Take It Down Act requires you to do it within, I think it's actually 48 hours, but it might be 24 to 48 hours. That's too little time to verify claims. DMCA
Especially
claims,
over Christmas.
right? DMCA claims take, if you want to actually look at what is in the content, make sure it's there. That's why there's so much just auto scraping of content on sites, because there's so much content. There's too much content for any one person to actually view. And if you get 100 Take It Down notices, are you going to review all of those? Maybe. But if you get 100,000 Take It Down notices, are you going to review all of those? No way. You can't even do that in 48 hours. So you're just not going to be able to take reasonable safeguards to make sure that the content that is being flagged should be flagged. So the ability to have that reasonable time to take down infringing content is one thing. The other thing is that it doesn't have any type of put back process. One of the things we haven't talked about the DMCA yet, we talked about how you get things taken down. But here's the process once that happens. You send a takedown notice to my website. I take down your content within a reasonable time. And then I send a notice to the person who uploaded that content and said, this has been taken down. And if you dispute that, if you don't think that it was improperly or uploaded or infringing, if you think you're in fact a copyright owner, if you think anything about this is wrong, you send me a putback notice. And I put it back. That's part of the safe harbor. I have to put it back or I risk being sued. So then it goes up and I put it back. And if I put it back, then I send a notice back to the original person who made the complaint and said, here's the name and address of the person who had me put this back. And if you want to sue them, go sue them. I am now no longer in the middle of this process. We've identified all the proper parties. We have a plaintiff and a defendant, and this can be settled in civil litigation. And in the meantime, the content that is not necessarily infringing is back up. So there's ways to prevent the improper takedown and the misuse of, and we still get plenty of misused DMCA takedown notices. It's not a thing that doesn't happen, but at least there's some process by which it can be partially corrected and the content put back for public viewing. There's nothing here that does that. And I can see why, in the mind of a legislator thinking about, the taking down deepfake content of high school teenage girls, which was the justification for this. No one thinks there's any good reason to put that content back up. There's never a reason why we would want to put that back into public space. But what happens when it's the political speech that got caught by accident? That's the remedy that's missing.
I just want to add two quick things to TJ's point. I have a friend who works in content moderation policy, and she's currently at a small to mid-size content platform. And she texted me and she's like, I keep hearing about Take It Down. Is this something you worry about? I was like, well, it's about deepfake sexual imagery. And she's like, oh, we got good policies around that. I don't think we'll have much of a problem. I said, well, there's also a 24 or 48 hour requirement to address any complaints. Then they sent her the provision. She's like, oh no.
Right.
And also, I would just say that the one thing that was the DMCA, I mean, there's a few things that I would say good about the DMCA, even though I'm critical about parts of it. One of it is it sets up a system by which platforms are protected as long as they act responsibly in adjudicating the claim, including if it was done improperly and you put the content back up, they're covered legally. They as long as they follow basically the manual of how to act, they don't have the legal liability problems. With the Take It Down, it's very uncertain. All of the incentives for these platforms are towards just being as strict and careful as possible.
So yeah, it sounds like there's a lot of unintended consequences. Is there any kind of potential for abuse? Open-ended question for anybody?
There is a lot of potential for abuse, and the problem is that, so Take It Down may get tweaked and changed over the coming years as it makes its way through courts. And I know some people who were hoping that there was going to be a litigation involving the South Park one, because they've got the lawyers who they are willing to pay to try and create some good law here. Because there is no way that anybody is going to be able to get something passed, not in this Congress and not in any Congress I can contemplate in the next, 6 to 10 years, because anybody who runs against someone who votes to change the Take It Down Act in any material way will be accused of being pro-child porn. And nobody wants to be accused of being pro-child porn.
Well, I think it can also be abused in the sense that, I mean, we talked about there are problematic DMCA notices. Imagine the ones here that just aren't even related to taking down non-problematic content. If I decide that I am suddenly anti-pornography, I start filing random take it down acts on every naked photo on the internet. And I want to take down every single naked photo and video on the internet. Again, you don't have time to verify that that's my content, that that's my copyright.
That's not the David.
I might get, someone who finally comes and sues me about that. But for just randomly firing off complaints, I could take down a lot of content that is consenting adults who put it there on their own. I could take down OnlyFans entirely. I could take down any site that is, I could take down the Metropolitan Museum of Art, playing naked people in that too. So there's no reason that we should not suspect that people will use this to push an agenda as much as to protect the victims. And we want to protect the victims. You're never going to get a completely clean way to make sure somebody can't file a malicious report without any legal grounds. But when you don't have any recourse for those improper takedowns, they become much more effective.
I 100% agree with what TJ said. It was that was definitely a problem that we had identified. Another one is just that because of the quick turnaround required, a lot of platforms, especially platforms that have to deal with these things at scale, are going to have to set up automated systems because they're probably not going to be able to get a human review it in time. And depending on the sophistication of the internet troll, unfortunately, internet trolls have gotten very sophisticated. They can figure out how to say the right things in these claims that will get these automated systems to take down broad swaths of content, including potentially like content that has absolutely nothing to do with sexual content, potentially political content they don't like, potentially like artists they don't like that aren't even, doing sexual imagery, potentially lots of different things. And, this problem I think is somewhat underappreciated. And one of the things that I found surprising and heartening is there's a professor, I think she's at Georgetown now, Marianne Franks, who I respect but almost always disagree with. And she's worked quite hard on this stuff from the position of protecting victims, women of sexual sort of, all sorts of problems online. And she actually agreed with me on, and when the article was written that I was quoted on, and someone asked about our arguments, and subsequently, like her center on this, she comes with Daniel Citron, another professor, put out a thing that says we like the principles of this, but we don't think this bill is a good bill, and it just had too many weaknesses in terms of how to deal with a lot of these sort of difficult speech issues.
I mean, what kind of changes would you all have liked to see or like to see in the future, even if it's not politically feasible? Imagine we live in a world where Congress can do something effective.
I am a huge fan of notice and warning. So if it was instead of, 24 to 48 hours to take it down, 24 to 48 hours, frankly, 24 hours, to notify the person who's been accused and to say that it will be, blocked for 48 hours. And if you don't reach back to us by that time period, like to have that kind of a process baked into it. And if you don't respond, within 24 to 48 hours, then it, will stay down until we hear from you, like to have something like that in it, because I am a huge fan of the quick notification process. I do think the DMCA can sometimes take longer than it needs to, but part of that is because they're technically required to do a fair use analysis first, and this does not require any there's no fair use, there's no, this is for news or educational purposes in take it down. But if there was something in there that had those kinds of milestones baked into it, then less content would be potentially removed. And I think that's something that explicitly, unintended, made it clear that text could not come down in connection with this. So you're only removing the image and not the entirety of the post, not the entirety of the content, would have less of an impact on information, because then it would be known within, 3, 6, 9 months that if you are creating political speech, if you are creating, a video to accompany it with a transcript or with, something informational, so that part would not be coming down at all, even if the image was being blocked, would reduce the impact on things being impermissibly pulled down. And also, sites use this as grounds to suspend or delete accounts. And I don't think that, and that's one way that the internet trolls can get accounts suspended or deleted. And if there was something in the law that said that it could not be used on its own as grounds to suspend or, cancel out somebody's account, or at the very least to suspend it for more than, 6, 12 hours or something like that. I think that would have been a much more sensible way to do this, because I see people, on Threads, not so much on Blue Sky, but on Threads all the time, getting their accounts suspended because there's been some sort of, a mass troll invasion of reports on those people.
Yeah, I think, I think I've been pretty clear that I would like to see the DMCA safeguards baked in. But the other thing that I think is both really, really good about the bill and potentially bad about the bill is the fact that sites need to also take down within that time frame all copies of the image, any other posts of that image. And that's great in concept, because one of the things that we have struggled with, if you're representing anyone who's had a revenge porn issue, is once something's on the internet, it's on the internet. It's everywhere. There's a million copies of that. And okay, this take it down post to YouTube isn't gonna get what's on Reddit, and Reddit isn't gonna get what's on Twitter, X, whatever. But
we can dead name that.
But the fact is that at least if I go to Twitter and set a takedown notice, Twitter is supposed to look for all those other uses. But how do they do that? They're going to look for, an automated image, and they're not going to see that other use was in a New York Post article about what they're not going to see that it was in. They're going to look for the Taylor Swift deepfakes. They're not going to look for all the news reporting on the Taylor Swift deepfakes. They're not going to look for the legitimate commentary on the Taylor Swift deepfakes. They're going to see that all connected to an image, even if it's blurred or altered in a way that makes it now not an offensive product, and take it down. And it allows for us to avoid playing whack-a-mole with individual copies of individual images, which is what we have to do for revenge porn. But it creates a window to capture those things. So what I would like to see is some language that requires, more than 48 hours to do this, but requires the site to say, I'm going to take down all copies of the photo that aren't connected to a legitimate fair use or other commentary, or that are, not in encrypted content, or that are not, I don't have to go search through private things to make sure that they're not containing something that's not public copy of this photo. That would be good language to add in my opinion.
Yeah, I agree with TJ on a lot of, and Heidi obviously on a lot of this stuff. I think that adding the DMCA protections is important. I think that carving out messaging, like private messaging, is potentially a big deal because I recognize and I want to name the fact that like these images do get shared privately in a very harmful way. But the answer to that, if you include messaging, is that these companies have to essentially surveil your private messages, give an employee access to read them and to check and make sure that the images, are sexual and violate this act. And like, and again, in sort of false claims, like if you're sharing, image with another consenting adult about anything, like you're bringing other people into this.
Right.
I would also say that, one of the debates that we have had with other organizations is that to name another sort of law that hated and then kind of grew to say, okay, well, maybe there's some merit here. There's a bill called the CASE Act, which is sort of like a small claims court for DMCA, like copyright claims. And one of the big problems and one of the things that we sort of were admitting that the DMCA model was better for this is that not only do these things have to happen quickly, because the longer they are, the more harm there is, but also a lot of these like laws are written from a perspective of like wealthy people or famous people, and those people have lawyers like on speed dial. Like they're like probably get invited to their lawyer's Christmas party. Like, most people don't have those kinds of relationships. I mean, to be perfectly honest, even like as someone who used to kind of practice law, I don't know who I would call. I don't have a friend that I would probably call. Yeah, but it's something that's happened to me. And it's also expensive. And so like mentally and financially, it's expensive to find a lawyer to get the rights. But the benefit of bringing judges and lawyers into this is that you have someone that like can look at the specific facts and make sure that everything is like above board, that like we're protecting speech, but we're also protecting people. And to have maybe just a mix of systems where, you allow actual humans to adjudicate this, where you provide a number or a board or something that you can call, get, if you need it, free or low cost counsel, get a quick adjudication from, an ALJ, administrative law judge, something like that. I think that would also be highly beneficial, but these are obviously things that are expensive, and a lot of government is, current Congress is just making someone else pay for solutions.
And actually related to that, something that's expensive, but could have been done in a prior administration, might happen in a future administration, is education about this. Because so I spent about 7 years having fights with my children's high school and middle school because of the way that they were teaching about social media use. And if you want to hear me rant, ask me about the FBI video. So basically, if there was education on a high school level, if high school guidance counselors had the training to be able to, do, even if it was just, 20 minutes as part of a health class, 3 times a year from, 9th grade on up. If college counseling offices had the information to give people on how to deal with this kind of thing, it would be, a very useful thing to have. Why isn't this included in orientation week in colleges, along with everything about consent and, sharing photographs and stuff? And here's what you do if there's a problem: DMCA and take it down. It's very easy to include. It's very easy to add. It's not part of literally anybody's educational process right now. And there's no reason for it not to be. Yes, of course, schools don't have as much funding now because of various government cutbacks, but this isn't the kind of thing that would be expensive. So if anybody has a lead to, social worker or guidance counselor or psychologist, school psychologist, education system, please talk to me because there could be so much more done because there's so much bad information on Instagram and Twitter and TikTok and Tumblr and Threads and Facebook. If any of the teenagers are using it, spoiler, they're not. It would be so great to have accurate information out there. I have been fighting this for 25 years on the fair use front. I have made absolutely no progress. People are still extremely confused, but this is something that theoretically could happen and there's no reason it shouldn't.
And I would just add to I's point, a few of the, or CDT, Center for Democracy and Technology, they have an education sort of wing where they do surveys and stuff like this. And they found that the biggest source of this problem is from like high school boys. And it's growing. And honestly, intervention there would probably solve a lot.
All right, I have one final question, then we can open it up to open Q&A. So if you have a question, start thinking about it. Last is, and you guys can take it whatever way you want to take this, but this act was passed in the vacuum of, for those folks who don't know, tech policy doesn't really happen on the federal level. We've been trying to work on federal data privacy law for over 20 years at this point. We still don't have one. We're one of the only G20 nations that doesn't. We also don't have a certain level of data security or data breach law. Most things happen on the state level. And we also have a lot of new technologies. We have AI that is increasing the amount of deepfakes that are able to occur. So I guess my open-ended question is, what is the importance of this act in this particular political moment?
So it's like the table, DC Critter, just to provide some of my perspective. I think that a lot of people, I have a lot of family and friends who are not. I grew up in Florida, North Central. My mom's from Atlanta, my dad's from Miami. And they kind of always assume that there is like this shadowy lobbyist, like corporate kind of environment that's always pushing what laws get passed and what laws don't. And that has a small part of it. But largely, like the show Veep kind of describes how Congress works more than anything. And so I don't have any bridges to burn with Cruz's office, so I could just say this bluntly. We weren't invited there, but we had a lot of friends that would go and talk to him on this. We weren't invited there because we put a billboard against him for.
Cruz was a sponsor of this bill.
Yeah, so he would. So Cruz is the basically the bill lead. So they are not only the original sponsor, but they were the ones responsible for keeping the language of the bill. And so any edits had to go through them. Largely what we heard is the reason why they didn't want to fix these problems is because they didn't want to shop the edits. So from like a mechanical perspective, like, how a bill gets made into a law, the one who's basically shepherding the bill, the original co-sponsor usually, of the party who's in control, whenever they have edits, they have to shop it around to the people who have already signed on. They have to get everyone back on board. They have to, it's like a whole process. They have to get all the allies that support the bill, make sure that they still support the bill, that they didn't do anything that they didn't expect that's going to like piss off some part of the coalition of people that are really behind championing the bill, and they just didn't want to do the work. That's what we heard. And so I think that, and that's kind of like something that happens quite a lot is we hear, that like they just don't care about getting things right enough. And yeah, so as far as the political moment, it passed in an area, like in a time period where like passing complicated law governing technologies is practically impossible. Probably passed in part because it was overly simplistic. And it definitely passed because Melania Trump endorsed it last minute. I think the content, the subject matter of the bill, just as sort of like an elevator pitch, got a lot of support for the bill. With a lot of members that just weren't looking under the hood, or staff that couldn't really fight for changes that would make it more comprehensible. But the thing that got over the edge was Melania Trump very publicly supporting it and highlighting like very real harms that I think everyone agrees with needs to be addressed. So that's kind of how a bill gets made in law these days.
Well, I think especially relevant to this time period is we talked a minute ago about how nothing gets passed in our current situation. And, for years, you couldn't get someone with an R behind their name to agree with someone with a D behind their name about the color of this tablecloth. I mean, we just can't, it's two team sports. We can't be allied with the other team in any way. This passed unanimously, nearly unanimously, if there was two holdout. And part of that is because it sounds bad, right? When you can say, I'm writing this bill, this is what Cruz put it out there. He had to go, Ted Cruz had to step in because of the deepfake issue at a high school where, again, we had a number of high school girls who were forced to change schools because of harassment from their classmates with deepfake news. And so we're reacting to that situation. And when you get reactionary law, you tend to not get great law.
Right.
Then when we're reacting to a bad thing, it's very easy to think we're doing the good thing. And we're doing the good thing, we're stopping that. But did we do it the right way? Did we do it the best way? Were we thoughtful and intentional about what we did? None of that, because we were reactionary and no one wants to vote against it to say, hey, whoa, maybe we should take some time to consider this, because then you're the guy who's pro kiddie porn. And that's not a good position to be in an election. To say the least. Or anything.
Yeah, go ahead.
Do you want to add anything? Otherwise, I'm going to open it up to Q&A.
I'm good with Q&A.
All right, let's open it up to Q&A. If folks want to make a line right behind that microphone if they have any questions.
Hey, I have a question about what you all think about what is a reasonable, a lot of talk about timeframes for takedowns or notices or whatnot. It seems to me it's faster and cheaper to produce this content. It's effectively animation, doesn't require any real actors. You can pump out content that's harmful at a much faster rate than it could ever possibly be moderated on any reasonable time scale. I mean, you already have time scale problems with manually generated content with DMCA, from what I understand. So I guess I'm just wondering, like, what is a reasonable time scale for review?
I think there needs to be a differentiation between a reasonable time frame for notice and a reasonable time frame for takedown. A reasonable time frame for notice for any company that has more than $2 million in revenue per year can be relatively quickly, one business day. By the next business day, you have to put out notice. I think that's completely reasonable. But for a company that has, one person doing it and under $500,000 in revenue, maybe a 3 business day kind of thing. But once you're talking about hours, you start to have to deal with timeframes over holiday season. And that's why you'll see every year during Easter week, Thanksgiving week, and Christmas week, the trolls come out and they get a lot of stuff taken down because everybody is understaffed during that time frame. On both ends, I mean, the major multinational media companies tend to shut down between the 23rd and, the 2nd or 3rd or even the 5th of January. So they don't have as many people who are available to respond to things. Yes, everybody's always got a lawyer who's on call, at that level. But it's not the same kind of a time frame situation. So I think that having a notice provision that's separate from a takedown time frame is extremely, extremely reasonable. And once you get into you have to respond by, I think you should be able to have a little bit more flexibility in that, because maybe a company does want to go to their lawyer, so keeping it to, under 5 business days isn't really fair. But we don't have a statute of limitations in copyright law anymore because of ridiculous rulings and people who were in prison who probably could not be keeping an eye on the internet to find infringements, but that doesn't. Anyway, not a huge fan of the lack of statute of limitations. That's another rant for another year. But basically, because we don't have statute of limitations for this kind of thing, and there isn't a statute of limitations built into either the DMCA or Take It Down, someone can really come at any time and say, oh, I've just discovered this thing. And then there's a question of whether the person who had that account is still using it, is still checking, the correspondence from it on a regular basis. How is the notice being manifested? So that's why, it's always a good idea to keep, one, if not two, correct, updated, connectivity aspects. But I think there needs to be, and that's one of the problems with take it down, is there's no differentiation between notice and takedown processes. And of course, as TJ said, there's no put it back.
Yeah, I think the concern with a notice provision, that would be if you say, hey, your deepfake pornography is going to stay up for 5 to 10 to 15 days while we go through the notice process. That doesn't necessarily. I mean, I for content generally, I think that's a great idea. I just don't know that that's in this particular context something that would be as meaningful to the victim. But the other concern to your question is, I don't know that there really is an answer for reasonable time, because if you send a DMCA notice or a take it down notice or any other kind of notice to my personal recipe blog, I could probably address that pretty easily. But again, when I'm YouTube, there is no amount of humans in the world who can address DMCA notices at YouTube. That's why it's all done by robot. So, and what's a reasonable time for the robot? Well, instantly, but you probably got it wrong. So I don't know that there's a great answer to the question.
I think that the answer to this is kind of tied up into the fact that most people, especially the government, don't really understand how content moderation works. And, it's something that I constantly have to learn from smarter people. And because of that, there isn't sort of the curiosity or the capability of the government to kind of work into these laws, the ability to, I guess, give corporations the ability to say that, like, you're okay, like, you're clear from legal responsibility as long as you act with these best practices that are changing over time. And so from my content moderation friends, I know that there are a lot of advancements in this. There are, obviously AI tools coming out. They get things wrong. Like, what do we do with it if it gets it wrong? Like, what do we do if it leaves something up that is wrong because it is actually a deepfake image that is problematic, or if it takes stuff off that isn't? They're not going to be incentivized to use these tools if they're going to get in trouble for that. Creating these different layers of content moderation, human checking, all these other things. And also just like, there is some communication now developing between corporations about threat identification and sharing, so that, like, if one website or platform finds that there is a problem that they're dealing with, that they can kind of send out a bat signal and say, hey, everyone, like, you should be dealing with this. There are also sort of like cat and mouse games, like hashing, like how do you take down everything at scale? You get a hash, and you check it against every image. That allows you to do it very quickly. Well, like you're saying, with deepfakes, you can churn out like 15 of them. And so it only takes one out of the 15 down. And so there's all these developments, but there's no real incentive to like engage in them, because the corporations are dumping money into trust, they call trust and safety. And it's just a complete cost, and they're not seeing benefit because the government's not rewarding them for making these things better. And so there needs to be some way of kind of like creating that relationship, creating that trust, and like being able to take advantage of the ability to just make better content moderation over time.
So I'm kind of wondering, if I were a bad actor attempting to take all porn off the internet or something along those lines, obviously I'm going to automate it. I'm going to build a bot that's going to do this. Given that this is a legal process, what recourse do the companies have to actually defend themselves against an automated assault like this?
I think they would have to take everything down and then deal with it. Like, as far as I know, there is no way at scale to go and look at every image and say, this is A, not deepfake, this is a real image, and B, person who uploaded it has the rights and it's doing it authentically. I don't know if anyone has a different answer.
No, that's kind of what I'm afraid of, because I mean, I don't see anything in the act that says anything other than you get a notice, you take it down within 48 hours. And
And
after
again,
that,
What's the enforcement mechanism? Like, what happens if somebody doesn't do it
I forget
correctly?
there is
or-
a penalty and I forget what it is. But if they get it wrong, they face financial penalty.
Okay. Is it like private enforcement, or is it like FTC? Anybody know?
I think there is a private right of action in this, but also there's a PR aspect of this as well. Because you have a situation where going and saying, Facebook is pro child porn is, the kind of thing that will get your stock to drop. And the kind of thing that might get the administration to stop working with you and giving you funds and things like that. So it's a risky issue for any company of scale to want to do.
All right, it doesn't look like there's any more questions. So panelists, do you have any other last minute rants or takeaways for the audience?
So I can talk for about 30 seconds about that FBI thing I was talking about. So if any of you have had kids in middle school, the FBI may have shown up to explain to them why posting on social media is a bad thing. And there's a video from like 2004 where everybody has flip phones. That they showed to the students, and they were still showing it 4 years ago when my daughter got to see it. And basically it's a girl, she takes a selfie and she's wearing a really cute dress, kind of like the kind that, they wear to parties at 12 and 13 years old. And it gets shared around the school and it's used to embarrass her. And instead of saying, don't make fun of people for what they wear, don't engage in body shaming, don't engage in, utilizing these pictures to, draw devil horns on or something like that. The issue is don't share selfies on the internet. And that's, what the FBI is, telling our middle schoolers and high schoolers these days. So they're not going to update this in the coming years, I'm pretty sure. But if any of you have kids, grandkids, nibblings of that age, having a conversation with them about, sharing selfies and sharing content, sharing other people's content, and directing them to, some of the things that Matthew mentioned that are really good educational resources. I'm on the legal committee for the Organization for Transformative Works. We have a lot about fair use. Giving kids the tools so that they, A, build media literacy, and A and B, are able to understand where actions are wrong and have the potential to hurt other people is something that is, I think, a positive thing that everybody can do.
yeah, I think the biggest takeaway I want you guys to remember though here is, for me, is that while we've talked about all the problems with this bill, and we're not wrong, the problem with this bill, it's important to remember that trying to create a remedy for victims of this is laudable. This is something that we should be trying to prevent. This is something that we should be trying to give remedies for. This is something that we should be trying to allow people a means to take down. The harm of the content being on the internet, and again, the ability to take anything down is limited with the whack-a-mole technique, but to have some way for people who have been put in this situation, either with their own legitimate photos that they didn't allow to want to be shared, or with deepfake photos that they didn't participate in the first place. That's something that foundationally we should be looking for as a society.
There's something that I will say at every con and every panel where I can possibly squeeze it in, and that is there's a lot of problems with how laws are made in DC, but one of the biggest of them is just that politically it is hard to pay staff what they're worth. And when you get lower paid staff, you get younger staff, you get early career staff, you get a lack of expertise needed to draft these bills. And so I would encourage everyone to politically signal to your lawmakers, pay your staff, hire better staff, and also bring back the Office of Technology Assessment, which was a nonpartisan a group inside Congress that was full of technologists that just gave advice to lawmakers. Whenever they had any problem, they could go and say, how does this work? And you would have someone with technological expertise and say, this is how it actually works. And so those are the kinds of things that we really need in DC to pass better written bills, and hopefully stop getting these bills that are like very well meaning, but like broken because of how poorly they were drafted, and potentially going to become non-constitutional because of how poorly they're drafted. So